CodeX group meeting for the spring quarter, and I am going to turn it over soon to our speakers. We have Giulio Suana from Leuven University in the Netherlands, who will talk about the blockchain's impact on the traceability of illicit financial flows. And we have Iman Kinan, the founder of Saif Legal Aid, talk about their solution for to help families analyze their family legal problems. And so two great presentations today. Before we get started, I wanted to see if anyone had any news or updates to share. And as usual, please use the chat function or unmute yourself so we can hear you. So Shugam is sharing some legal prediction publications that came out recently. Thanks for sharing the link to Oxford University Press. Congratulations. And Lance is keynoting at the iTech Law Conference. Congratulations for that. That's great. And Scott sharing some news about the World University Law School. All right, wonderful. Thank you. Good. All right. Well, good to have you all. And I think we'll turn it over first to Giulio. Giulio, are you there? Oh, yeah, I can see you. Great.
Yes. Hello. Hello, everyone.
Hi, and welcome. It's great to have you.
Thank you.
And yeah, it's already late in the evening in Europe. Are you in the Netherlands or where are you?
I'm currently in Rome, but yeah, it's 10:30, so it's not that bad. It's okay.
All right, great. All right, wonderful. Well, all right, we'll turn it over to you. So we have an hour for our group meeting, and so two speakers, that leaves each one half an hour for both presentation and discussion. So I would recommend about like maybe 10-15 minutes of presentation and then leave the rest for discussion.
Perfect. Thank you very much. I'm gonna start sharing my screen.
Yeah, go ahead.
Right. Okay, you should see that.
Yes.
Right?
Wonderful.
Okay. So thank you very much for the invitation, and thank you for everyone that participates today. The aim of today's presentation is to study and understand how the legislator can and has interacted with external shock to the architecture, which undermine their policy strategy or facilitate, in this case, undermine. Now, there has been quite a lot of research in the last decades about the role of architecture in a digital society as a mean to regulate. However, less has been said about how the legislator has to act when the architectural shock is external. And this is exactly what has happened when it comes to blockchain and the legislation surrounding financial integrity. And so I will use this, and I'm using this in my research as a case study to let's say, to deepen, to delve into this relationship and how this creates a dialogue between policymaking and technology. Now, let's start very briefly by understanding what financial integrity is. Here you see a bottleneck, and that's because bottlenecks are the heart of the financial integrity strategy. And that's because the financial integrity strategy is based on one architectural postulate, and that is, in digital economies, when you need to transact, you need to pass by an intermediary. And this means that intermediaries become information bottlenecks. They hold a great amount of data, and they can therefore perform control activity, both subjective, so identifying their clients, and objective, so monitoring their transaction, to make sure that the financial system is not used both by criminals as a means to, let's say, to perpetrate their crime and to enjoy the proceeds of their crime. So the whole idea is that if we regulate these informative bottlenecks, then we can create, and we have created since the 1980s on, more and more sophisticated means to control a first line of defense to avoid the contamination or the misuse of the financial system. Now, why does blockchain change that? Now, blockchain, and here I will be very brief for reason of time, can be seen, first of all, as a change in the architecture of trust, as underlined by Professor Verbach in his seminal book. Blockchain changes the way we administer trust in complex societies. And to be more specific and to go, let's say, more on our case study, what it does is one specific change, which is if I need to send money in the traditional digital architecture, I need to pass by a bank. I need to pass by an intermediary. Whereas when it comes to blockchain, I can send money peer-to-peer. And what does this create? This creates a problem for the policymaker because its policy strategy, it's not valid anymore. It's not valid because it's rooted in a postulate regarding how the world works, about what people can and cannot do, which is at least, I would say, the definition of an architectural norm. This doesn't hold anymore. And I think it's important to underline that here, this architectural shift is not an architecture, it's an external architectural shift. It's not from the legislator, but it's still a normative architectural shift. As underlined by Professor Branton, digital currencies are a cosmogram, meaning with the term cosmogram, not only a technology, but a technology that brings about, that expresses a way of seeing the world. And digital currencies were a way of seeing, were a representation of the way that a certain philosophical internet philosophical movement saw the need to free the individual. And so they were expressly taught as a way to modify the architecture so to enhance privacy and avoid this type of controls, this type of financial overview. So now what is the next step? The next step is understanding how did the regulator, let's say, approach this kind of change. And here, let's say here, when we speak about the regulator, it's more like a standard setter. We are speaking about, in this field of financial integrity, we are speaking about the Financial Action Task Force, which is an independent body of the OECD, and which is, let's say, a global lawmaker, soft lawmaker when it comes to financial integrity. And as you can see, here legislation has come very early on. It's one of the fields where legislation has come the earliest to underline the, let's say, the urgency that was felt because of this, let's say, of this shift prompted by blockchain. And it came mainly because of a Silk Road case. Already in 2015 was the first guidance, 2014 is the first report. Then the second guidance in 2019, and the third one in 2021. But now what is interesting to us is what was the strategy? How did the regulator, the standard setter, grapple with this change? And we see three phases, at least in my perspective, we see three phases. The first one being from 2014 to 2018, the second one being from 2018 to 2021, and then a third phase, which I believe has kind of changed the rules of the game. The first two phases, they employed a traditional approach. What do we mean by that? The first phase was basically a phase that we can define fencing. Fencing meant that the legislator tried to regulate all those points of contact between the crypto or the virtual asset world and the let's say, traditional world. So exchanger, from fiat to crypto. So that was the idea. The idea is to avoid any spillover. then they understood that this was not a really functioning strategy. And so they tried direct intervention. They expanded the scope of the regulation. They extended the number of intermediaries that were considered, that were, let's say, regulated. And but this still left a big hole in the regulation. And this was accepted by both the FATF and, for example, the European Union itself, which was the fact that there was a big chunk of transaction which before were under the radar and that now were not under the radar, which were the transactions that were being done in a peer-to-peer fashion. So the regulation was still focusing on intermediaries, so was still having a traditional approach. Now, I believe that this changed with the 2021, and it changed, I believe, in a very interesting way. In what sense? In the sense that the legislator, for the first time, has tried to interact, to engage with the architecture, so to change it, so to modify it. In two main ways, I believe, if we read the last guidance, The first of all is to move the market in the direction it feels, in an intermediated direction. And this has been done mainly through the travel rule. I'm not going to go in depth in the travel rule, but what I will say is that the regulation of the travel rule, and in particular the decision of the European Parliament, which is still not law, to apply the travel rule also to unhosted wallet, makes transaction between intermediaries and unhosted wallet very expensive, or very expensive from a compliance perspective, or per se high risk. And this means engaging with the architecture and pushing the architecture towards your direction. And the second one is the inclusion of software developers as virtual asset service provider, so as intermediaries, so as regulated intermediaries. So what does it mean? It means, okay, you are creating a DeFi application, you're creating a smart contract, which I will not be able to regulate after, because there will be no intermediaries then. Then what do? I say, you, at the moment in which you are computing that system, then you are a regulated entity, and you have to engrave in the code the compliance. So this means, on one hand, working on the compliance by design, so the legislator starts to use architecture as a means to regulate blockchain. And on the second hand, it is also trying to affect the architecture towards its policy means. Then there is a second moment. This, I would say, it's the reactive approach. This has been the reactive response to blockchain, to this kind of blockchain shift, a reactive response to a pre-existing market, to a market that is outside of the regulator. But then the regulator has also institutionalized the technology. So has also taken the technology and worked on it and used it and modified for its own means. And this, I would say, it's well represented by the central bank's digital currencies. Central bank digital currencies represent, obviously, by design, so then it will depend on what will be done with them, a dream of any financial integrity, let's say, supporter, because obviously when it comes to blockchain, if mandatory identification is imposed, then the information structure of blockchain is much better from a control perspective than the one that existed before, because now we have an information structure that is based on ledger that are divided, that are fragmented, and that are privately held. Here we would have a logically unified ledger, which then is distributed from an access and maybe in some cases also a control, let's say a governance perspective. Now, if we see what in 1975 Paul Armour laid down as in his seminal work on the, let's say, on control through financial transaction, what were the three elements to evaluate how controlling would transaction infrastructure be. He said it depends on the percentage of the transaction recorded, on the degree of centralization of the data, and on the speed of information flow. And we can see that blockchain, in this case, has a much higher, scores much higher than our traditional system. And so this is interesting because this is not a reactive, but is a proactive approach, which changes the narrative on financial integrity, because here, it's not financial integrity that will have to be implemented. It will be privacy that will have to be implemented. And this is completely the contrary to the traditional system and to the cash system. So what can we learn from this? Obviously, this is far from being a closed story. This guidance is of 2021. And it's very early to know. But on one hand, I think it's very important it's a very important cautionary tale for anyone creating a technology to spur a certain social change. Using technologies to force social change can sometimes create very different results from those that the creator had envisioned, because the legislator, the regulator, the society will engage with this new architecture, will engage with this technology, and will both bend or try to bend the pre-existing technology and institutionalize and get it inside him, the technology, so to reuse it to its own means. And on the other hand, I think it's very interesting because it is also important from a fundamental rights perspective, from a legislative perspective, to understand how to regulate, how should the legislator engage with new architectures, both when they restrict, but I would say much more importantly, when they expand its power. Because when you interact with the architecture, both expansion and restriction are not transparent. They do not happen through a legislative process. So I believe that it's important to study how this dialogue works and try to regulate further this dialogue to ensure that it is transparent and that it still respects our principles in terms of rule of law and of participation and of procedural fairness. Many thanks.
Wonderful. Thank you so much. All right, folks, questions? And please unmute yourself so we can hear you, or use the chat function. So what is how does this place into your broader kind of research interests? Is this what does this project belong? And by the way, I should correct what I said before. You're at University of Leuven, which is Belgium. It's in Belgium, not in the Netherlands. Anyway, so
so it's in Belgium, but it's on the Flemish part, so they speak Dutch, we speak Flemish. So if so it's very still in Belgium. So within my, let's say that my project is studying this interrelation, obviously going much more in depth when it comes to both the legislative approach so far and on the legislative approach going further. And I think that the focus will be also to, as more and more the legislator approaches with this architecture, is understanding how we can ensure that this dialogue still guarantees fundamental rights, and it's not done in a merely technological way, because the problem is that this kind of regulation are done on a technological level, and many times the impact in terms of classic criminal law and procedural criminal law rights do not really come out, because it's very unseen. I think it's a very non-transparent process. And so that's the idea, is to study this relation and to underline this kind of criticality.
Okay. Peter's asking if you can share a bibliography of the sources related to your talk.
Yes, absolutely. I can share it with Susan, that and then I think she can share it with.
Yeah, actually, we suggest that our speakers drop their emails into the chat, and then anybody who wants more information can receive it directly.
So yeah, that would be great. And is this sort of a comparative project, or are you talking about all legislators around the world, or the legislators in Europe, or is there sort of are they all aligned on issues, or?
So financial integrity, it's a very specific field. It's a very specific field because I would say it's one of the only field where you really have a global regulation. So the Financial Action Task Force, which was the body that I was speaking about before, is a standard setter, but it's a standard setter which is very, very effective. Also because it pursues evaluation of the states, and this evaluation have a direct impact on the rating, on the risk rating of the state, and they also impact the ability of the state to access the financial market. So I mainly study let's say my legislative perspective is on the guidances of the Financial Action Task Force, but because they tend to be very representative of the legislation, at least, for example, in Europe, the legislation in Europe is all in financial integrity is done directly at the European level, and they're mostly the legislation are copy-paste of Financial Action Task Force guidelines, especially because states participate in the creation of these guidelines. So I would say that it's a field where you can rely on those specific, let's say, global guidelines.
Yeah, and how does enforcement look like, both in the traditional system with the bottleneck, against banks or financial institutions, versus enforcement against certain, financial smart contract creators? How's the regulation foreseeing that enforcement will work?
So until now, the enforcement has been basically the same, because so you have to understand that between being this a standard setter, between the guideline and the actual hard law, you have a certain time lag. So I would say that until 2021, until this new guideline, which has mainly not been still introduced as hard law in countries, the idea was still to regulate intermediaries, which has been a very ineffective. But basically, what has been done is to identify wallet providers, exchangers, and issuers, and basically all these, let's say, all these intermediaries, and regulate them in the same way as a financial institution is regulated. So a bank has the same duties as a virtual asset exchanger. So there was no customized. So this customization, for example, what I was saying before about regulating the software developer, which means saying to the software developer, if you're creating something that will be autonomous, then you have to do it now. Then in the design phase, you will have to do. And I think this also represents a bit of a shift. Also, if you see the artificial intelligence regulation in Europe, also there you have had a bit of this shift about trying to regulate more the designers. So try to say, we want you to create these safeguards before you put something in the market, and it has to be by design. So it's a bit of a shift from ex ante, from ex post. So after the fact, I punish you, I find you, I punish you, I regulate you, to ex ante, before you actually act, I already want you to be compliant.
Right, that makes sense. That makes sense. Okay, any other questions? Anyone in the group? Is there anything, I mean, there was a lot of discussion around, this might not be part of your research, but there was a lot of discussion around the use of blockchain for illicit money transfer to fund the war in Russia, as Russia was turned off from the SWIFT excluded from, or many Russian banks were excluded from the SWIFT system. You have any insights on that you could share?
I mean, it's basically the same idea, because the anti-sanction, it's based on the same idea. It's always control of financial flows. So why is it possible through not blockchain, through cryptocurrencies? Why is it possible through cryptocurrencies and it's not possible through banks? Because obviously, as long as I am moving in the peer-to-peer arena, as long as I am doing peer-to-peer transactions, there is no one that can regulate me. So if I want to send money to a Russian counterpart, let's say, which is sanctioned. If I exchange my money through a wallet provider, through an exchanger, but then those money are sent to my personal account, the wallet provider, the exchanger, does not have to verify who am I sending. He has to ask me, so who are you sending money to? And I say, I'm sending money to Giulio. That's it. But then once I have my money on the unhosted wallet, I can send the money to another unhosted wallet, or I can send the money to an exchanger in Russia. And there is no way to freeze this transaction, or even to really see this transaction to let's say, because the transaction control system is based on intermediaries. And if there is no intermediary, there is no way to control.
Right. Okay, Fernando's pointing out that it's almost certain that in the crypto community, the regulation made by one country alone will never work. I think you will agree with that. But yeah, he put a link to an article on that topic. Thank you very much, Fernando. And anyone have any other questions? How, in your view, what's your view about DAO regulation?
Yeah, so DAO regulation is basically what I was saying before. Basically, if you see the new guidelines, but also if you see the MiCAR regulation in Europe, so the market in crypto asset regulation, the idea is to shift to the design phase. So the whole idea is to say, okay, you are creating something that I will not be able to regulate. Then I want you to embed certain regulation, which are most importantly, usually the financial integrity regulation, so money laundering, terrorist financing, and data protection regulation already in your white paper. So there are for example, in the MiCAR regulation, if you go and have a look at it, there are specific requirements for white papers. So when you do a white paper, you already have to explain those specific things. And then the second point I would make is that both the financial integrity regulator, and I speak for Europe, the European regulator, are increasingly wary about the fact that DAO many times are not DAO. And so they are taking increasingly a case-to-case approach. And they are saying, okay, you have to go and see. And for example, who's receiving money? So, okay, no one has a governance, but is there someone receiving money from this DAO? And that guy could become a regulated entity. So when it comes to DAO, I think that especially for developers, it is important to be very careful, because now the regulation is going on the developers, and it's also going on say, okay, this is decentralized, but how decentralized is it? And can we see someone that from a traditional perspective, it's actually managing this?
All right, got it. Thank you so much. We're pretty much at the end of the time for the first presentation. Giulio, it was really wonderful to learn from you, and thank you so much for sharing your insights with our group. And folks, if you have more questions for Giulio, please reach out to him directly. His email is in the chat. And thank you again for joining us from Rome. And we'll turn over to our next speaker now.
Thank you very much.
Thank you again. Giulio, sorry.
Al, can you hear me okay?
And next we have Imon Kinan. Imon, there you are. Am I pronouncing this correctly? Or?
It's Eamon, close enough.
Eamon. Okay, Eamon. Okay, well, great to have
Great.
you, and we're curious to hear about your TurboTax for family law situations. So over to you.
Thank you so much for having me. So hi, everyone. My name is Eamon, and I'm the founder of Safe Legal Aid. So we're a 501c3 nonprofit based in Chicago, Illinois, and we build tools and services designed to help folks who can't afford a market-rate attorney find free and affordable solutions to their civil legal problems. And I'm especially excited to share with you today and to demonstrate our first product, which we launched just last month, which is a free tool designed for folks in Chicago who are looking for free and affordable legal help for family legal issues. So issues such as those pertaining to child support or divorce or child custody disputes and things of that nature. Before the demo, I'd just like to start by sharing a little bit more about the genesis of this project, as well as how I came to encounter some of the problems that we are looking to help solve. So about 3 years ago now, after the second year or summer after my second year of college, I worked at a free legal advice desk in Chicago in intake management. And this advice in particular provided legal advice to self-represented litigants who had legal issues pertaining to either child support or paternity exclusively. And so on my first day of the job, I was sat down to the front desk without any formal legal training and was told that my task was essentially going to be to diagnose the legal problem of each person that came to the desk and then relay that information as efficiently as I could to the two staff attorneys that we had so they could spend the majority of their time, just preparing documents and preparing whatever they need to do to provide substantive legal advice to the litigants. And it did not take me very long to realize how inefficient the distribution of legal advice and legal services can be to self-represented litigants. And in order to illustrate that, I'd like to share an example of experience I had helping this one individual who actually helped on my first week of the job. And for the purposes of this, I'll be using a pseudonym. So George came to my advice desk because he recently had been ordered by a judge in court to start paying child support for his child, which he was perfectly happy to do as he wants to support his child as best he can. The issue for him was that the amount he was ordered to pay in child support was purely unaffordable for him. It meant that he wasn't going to be able to make his rent going forward. So he came to the advice desk looking to see if we could try to adjust the amount that he was ordered to pay, which is often very difficult as these sorts of procedures can only happen under very limited circumstances. So to sort of illustrate the precarity of George's journey in trying to find legal help, I'm going to backtrack to when George first went to court. So after he got home from court, the first thing that George did was Google search free legal aid, which in Chicago he happened to qualify for. So what he does is calls the first number he sees on the Google results page, which ends up being one of the larger legal aid providers in the city. But once he gets on the phone, he quickly realizes that he isn't able to, effectively communicate the nuance of his personal legal situation. So the intake manager on the phone tells him that one of their attorneys will call him back in about a week to follow up on his problem. Fortunately, after the attorney calls him back and diagnoses the legal problem, they inform George that they don't do child support modifications and that he should instead try to get help from the advice desk that I worked at. And so on his next day off from work, that's exactly where he goes, but he had no idea that he needed to bring copies of his pay stubs before we could even help him draft the modification. So at that point, I had no choice per my attorneys, but to say, sorry, come back on your next day off from work and maybe we can help you then. By then, when he came off his next day off from work, it was too late for us to help him. He ended up missing a filing deadline that he was never properly made aware of. And the attorneys at the desk said there was no other way that we could help him get a modification at that time. And there was likewise nothing we could do to save him from inevitably drowning in child support debt. And for me, this experience, not only having to, because I worked in the front desk, be often the bearer of bad news, and in this case had to tell George that we couldn't help him, which was often very intense and heartbreaking. But it also just showed to me how in the civil justice system, something as innocuous as a missed deadline or a lost document can mean an unavoidable lifetime of financial turmoil, or families getting irreparably separated, or even some periods of incarceration, which to me was just mind-boggling. So I definitely left this experience wanting to find some way to help those like George. And the first thing I came up with really was just thinking of what if there was a place that George could have gone to find the legal help that he needs on the day that he calls or walks through that legal help provider's door. So that was the goal. And speaking as someone who has zero technical expertise whatsoever, and we didn't have any funding at the time, I needed to find some way to be scrappy with developing MVP. And I was very lucky to get our MVP developed by the Flatiron School out of Colorado, which is sort of a UI UX bootcamp that at the time was offering a free service to help their students sort of work with early stage startups for free to get product development experience. And this is the MVP that they were able to develop for us through that program, and also conduct user testing and customer discovery on our behalf. And the idea that I had going into this product was that the biggest thing that we could help with was sort of educating the litigants on sort of the core legal concepts that they had to deal with. Because from my perspective, where a lot of the confusion came from in terms of having the litigants try to figure out what their problem was and find out where to go for help, was a lot of confusing terminology where they think that they're talking about one legal issue from an attorney's perspective is an entirely different legal problem that requires an entirely different set of services to help with. And so what we made the platform was a questionnaire that was designed to sort of educate the user on core legal concepts in order for them to answer the question. And very quickly into user testing, we realized that users were not quite understanding all the information we were presenting and not answering the questions accurately. And more importantly, what we learned is that from the user perspective, in terms of their self-confidence, like if they aren't confident that they can understand the question, then they don't feel confident they can get what they came to get out of the service, which was in our case to get legal help. So what we realized is that we really need to rethink and recalibrate everything and focus on trying to find a way to make this platform as accessible as possible while still trying to get all the information that we needed to provide users with accurate referrals. And so we really tried to focus on how we could sort of approximate these core legal concepts through plain language and make the platform as simple as possible. So after getting a little bit of grant funding from an accelerator program, we were able to find some freelance developers to help us develop the first beta version of our product. And I have some screenshots below. So we sort of try to really streamline the problem identification process for the litigants. And then on the screenshot on the right, you can see rather than in the first version of the questionnaire, we would just ask the user whether they are the custodial parent, which really just means, do you have primary custody of your child or not? And then have them learn about what that means and then therefore answer the question based on what they've learned. We try to approximate that question in plain language. So here we just ask, does the child live with you more often than live with their parent? And we are trying to accept that we're going to lose a little bit of accuracy, but overall make the platform way more accessible and overall increase the level of user engagement has with the service. So now that we had this closed beta testing done, we did in-depth feedback and user testing session with a group of about 40 users for this in 2021. We had a pretty good sense of the UI UX that the direction that we wanted to go for the platform, but what we really needed to hone in on was making sure, or sort of hone in on a core part of what we felt like our pitch needed to be, which was that we can leverage low cost, simple to use, accessible technologies to generate a lot of impact. And we felt that in order to really do that, the platform needed to be super scalable without having high technical expertise. So that was really our main focus going into building the next version of the product, which is we just recently launched. So I'm going to go ahead and go into the demonstration. So what you should all be able to see, hopefully, is the front page of our website. And so similarly, we went with sort of a situation where the users have to identify what they believe their problem is, but a core part of the service is whether or not the user actually identifies their problem accurately is not necessarily where they're going to end up. Though based on the questions we ask, we will always get them to the right area of the law the problem falls under and make sure they get accurate referrals. But if the user isn't aware or isn't sure what category of the law or family law their problem falls under, we do have informational pages where the users can look through all the different types of cases that we offer, figure out what it means and who can actually bring these actions to a court case if they are confused. But for the purpose of this, we'll say the user wants to get help with something pertaining to child support, or that's what they believe their problem relates to. And once they accept our TOS, we first bring them to sort of this optional page in which we refer to as educational modules, the purpose of which is really to sort of educate users if they want to on sort of the core legal concepts for each category that we're trying to find them referrals for. So for the child support one, we educate them on the fact that the importance of the status of being the legal parent of a child determines whether or not you can actually proceed in a child support case or not, or that there's actually 2 different types of child support orders, and depending on which one you have can really determine the types of services you may need if you need legal help and where you need to go for legal help. And so if the user wants, they can read through and very easily figure out how to tell the difference between the 2 types of orders, things of that nature. But the user can go ahead and begin the questionnaire whenever they want. So the first thing that we do is a required intake in order to determine some specific eligibility standards for the organization we're providing referrals to. So the first thing, the user selects their county, and we are for now totally focused on Cook County, Chicago, but we recognize that just given the resources of the courts in Chicago, there are often people out of state who find themselves involved in legal matters in Chicago. So anyone can use the site in the state of Illinois, but we do caution them that it's only for people who have a legal problem that they need resolved in the city of Chicago. So for the purpose of this, we'll say that this user lives in Cook County. We next ask them about their household size in order to calculate what percentage of the federal poverty line they fall on for eligibility standards. So we ask them whether they're above or below 150% of the federal poverty line, 300%, and then continue. Next, we have sort of an optional demographic survey that is very relevant for some organizations, specifically for organizations that have certain parts of grant funding earmarked to help certain populations with certain legal problems, or specific resources that are geared towards veterans specifically, or for survivors of domestic abuse, things like of that nature. But it's totally optional for the user to decide whether they want to share that information. And then once they complete that, they'll actually get to the questionnaire. So we sort of think about this in 2 layers, where the user first identifies the general category of what they believe their problem is, and then go into sort of the subcategory of what type of action they would like to take within that larger space of the law. And so we're going to say for this purpose that the user wants to accomplish is to start receiving child support payments from their child's other parent. So the user will select getting child support from another parent. Here we can see again, this is another question which we're trying to approximate in plain language. Here we're just asking whether the user has primary custody of their child, and if the user doesn't quite understand the question or wants to know more about the legal nature of the actual substance of the question, we have these little explainers that show, for in this example, hey, like what we're really asking is whether you're the custodial parent. If you don't know what that means, here is an article you can go to that explains what custodial parent means in plain language to assist you as you fill out the questionnaire. So they'll continue. We'll say that they are the custodial parent. And then here's an example of a question of a situation where we can't really avoid asking sort of about a legal status for the purposes of providing referrals. And so rather than relying on having to educate the user on what it means to have legal parentage established in this case, we do have an explainer to assist them if they want to, but what the user can just say is that they're not sure how to answer this question, and then we'll run them through a simplified version of questions that sort of ascertain whether paternity could have been established. So like if you were at the hospital when the parent was born or when the child was born, then you might have been offered to sign a specific form that established the paternity. Maybe they're not sure about that, but maybe they are sure that they were married to the child's parent when this child was born, which means that you're presumed a parent and then you become the legal parent. So there's all these ways in which we try to essentially just approximate these legal relationships and add additional forms of plain language questioning in order to sort of offset areas in which we really can't avoid trying to approximate legal relationships. But for the purposes, I'll just continue with saying yes to get to a referral page. So we'll say that we're not currently married. Child is under 18. All very standard questions. Try to keep it simple with yes or no as much as possible. So we do know, does not have a job. And then here we actually get to the referral page. So in this particular case, we only have 1 referral, and we really do try to pare down as much as we can to 1 or 2 referrals, just in terms of actually categorizing each problem with as much nuance as we can, just to streamline for the user's sake. But there are instances where we have up to 6 different organizations that can help with that individual user's problem, and we categorize them based on whether they offer free services or low-cost services, which are at least 40% below what market rate attorneys are for family law in Chicago. We typically try to provide just general basic information on these pages, like whether they have to expect to pay court fees, the types of services. We're looking to explain this in more depth later on. But if the user is interested in this referral, we provide a lot more information specifically in terms of how to apply for these services, all their contact information, the cost they expect for the service to be, what items in particular need to bring. So like if George was trying to go to the child support help desk, he would know at this page, if he filled out Safe Legal Questionnaire, that he needs to bring copies of his pay stubs before he can get help. So we can find all that information there. And then lastly, really quickly, in terms of time, just in terms of the element of scalability of this site, I just want to show you really quickly sort of the backend architecture of this. We built sort of a very basic front-end interface that we're looking to build on, but just to show you really quickly, as someone who doesn't have technical expertise, just like me, I can go in and see all the different questions that are in the questionnaire. I can very easily look at the content of them. And if I want to change the way in which we ask the question, the supporting information with each question, anything like that, where they lead to, I can do this very easily. Or if I wanted to even add my own new referral, that's very easy. I can just put in all the information I want to, select what organization applies to, and we have all these sort of categories laid out. And the goal of this is, if the partners of our referrals want to sort of be more active in editing the content of the referrals that we provide them, they can do that, hopefully for a more simplified user interface through this platform. So I'm going to go ahead and go back to the slide. And I just want to touch on briefly, so we just launched this product, and where we're going from here in terms of distributing the product is we're really trying to find community-based organizations in the city of Chicago that are currently serving our target users. So we're trying to find nonprofits of the city that provide parental support services, or trying to find community spaces around the city like homeless shelters and churches that are offering human services, really anywhere where we can, just say like, hey, if you are serving people that are living in poverty, the odds are they're going to have a civil legal problem, and the odds of them having a family legal problem is just as high. And if they need help with that, you can use our site for free and provide them with free information and accurate referrals. So hopefully that will be a way to sort of introduce ourselves to the communities that we're really trying to help, and get some early distribution going on the service. So with that, say thank you very much for this opportunity.
Great, Damon. This is a great project. So as I understand it, is you're basically information service and matchmaking service with legal help, variety of different legal help groups. And so I have a couple of questions. So one, you said you got help from the Colorado Flatirons program. Can you talk a little bit about, that sounds like there were law students and computer science students involved in work?
Yeah, so it was, it's, for postgraduates technically that are trying to sort of look for a career change and try to enter into the design field. So it's for entry-level students. And so the deliverables were anything from like very low fidelity mock-ups to like the level of prototype that you saw that was sort of on the higher end of what they were able to produce as students. But really the project was, based around the idea that the Flatiron curriculum wanted to provide those students with an opportunity to actually engage in depth with the product development process. So they wanted us to really hold off on a lot of customer discovery when we were building their product so that their students could do that, which we were fine with. And we worked with them on, establishing what our goals were and the parameters. They were very receptive to that. And for someone like me who had never done this before, I was a philosophy major in college. Like this is totally new stuff to me. It was super helpful just kind of have the design process broken down for me and sort of get, our goals in line in terms of where the product development process would go. And MVP was great for us specifically because we wouldn't have been able to find anything as close to that with the funds we had, which were nothing at the time.
Cool. And are you sort of also foreseeing the possibility that you might actually use your system to help people like complete certain forms, and you walk them through the form creation automatically, maybe even help them submit the forms directly to the courts? Or is that not part of your plan? You always want to basically educate them and then hand them over to a specialized attorney, making that right match there.
Yeah, so I mean, ultimately our goal is we want to increase the capacity of the civil justice sector at large. So we believe that if we can refer more of the right people to the right organizations, they're going to be able to help more people and generate more impact. So along that lines, we don't see ourselves as directly connecting the users to the organization right now. Like we see ourselves more as like a business card referral. But we do think in the spirit of increasing the capacity, one big thing that we don't want to do is just refer users who have something they can easily do on their own, like fill out a simple motion, or, draft a parenting plan or something like that, an attorney could, spend that time helping with the client that couldn't do that on their own. So we're really looking into trying to find these sort of like simple self-help tools that we can provide for very simple problems. But what we don't want to get ahead of ourselves is assuming that we're diagnosing these problems accurately and then offering all these self-help services. Like, we really want to make sure that the core service of identifying their problems is accessible and actually accurate. And then we're going to look for trying to add these sort of self-help tools to make sure that we can just create the ecosystem, be more efficient for everyone involved.
And how, at the moment, I understand you have about 6 kind of those legal aid groups that are involved. What's the kind of algorithm you follow in matching, like, one group with a specific client?
Yeah. So it's all very low tech, and on the one hand, that requires a lot of coordination individually with these organizations. So we're constantly trying to talk with them and make sure not only what are the problems that they're currently servicing, but also what do they expect to change in terms of their service offering, because grant funding isn't always guaranteed and they might not be able to help a certain demographic of people based on the funding they don't get in the next cycle. And so it's all very low tech and it's all customized. So we ask each organization what types of general cases that they offer, and then we go from there to determine what are the sort of elements that are necessary for referral. Like, we're not focused on trying to do all the high level triage to diagnose like every part of this person's problem. Like, all we're focused on is making sure that we can 100% confidence refer this person to this place to get help. And so that level of coordination with the organization is pretty easy to figure out what they service. It's just the actual development of the questions and sort of like picking out the nuance between one very, very similar case to one other not so similar case is hard. But in terms of actually coordinating with the organizations, like we have a pretty good sense of the types of problems they help with. It's just up to us in terms of developing the questions to match that.
Okay, and so what's your business model? Is that you sort of funded with philanthropic gifts, or are you looking to charge your member organizations a fee to use the system, or both?
Yeah, so right now we are incorporated as a nonprofit. We are fully philanthropy funded at the moment. There are some pathways we see towards monetizing the product, but specifically, we do want to sort of include private firms that offer alternative billing services geared towards low-income consumers, like a la carte services and limited scope agreements. So we could see some private firms wanting to pay for services, but on the other hand, we see like a real core value of our product as being sort of an independent connector for all these different resources, and we don't want our referrals to be based on where we can get the most money off sending users to. We just want to provide users with all the information that they can deal with themselves on where they want to go to get help. So it's something that we're constantly talking about. Based on comparable analogs to different services, most legal information providers are 501c3 nonprofits that mostly get their funding through philanthropy. We certainly believe that there's enough philanthropic funds out there once we sort of get to the stage of tracking outcomes robustly and have a product that we know is good in diagnosing people's problems accurately.
Okay, great. So I want to turn over to some of the questions that people asked in the chat. I think you already, answered in part Fernando's question, which he asked whether you supervised machine learning and how did you get your data set? You said it's all very sort of low tech at the moment.
All handwritten, yeah. Very monotonous and very time consuming, but we believe it's worth it.
All right, then Anthony is asking, how do you differentiate between clients with different reading comprehension skills?
It's a very good question, and something that is a very huge limitation on the current user testing that we did. Our plan was pre-pandemic that we could just go to the courthouse and find people who came out from court and ask them to use our product. The courts are closed still. So what we did was find a lot of people through digital platforms like Craigslist, Facebook ads, things like that. But the problem with that is, those users that we tested with already have a level of digital savviness that allowed them to find a Craigslist ad and sign up for a paid participation study, which is a much higher level of digital savviness than those who are really in the most need for free legal help. So what we're really trying to do is build the platform to be as simple and accessible as possible to the most inaccessible populations, so that it's accessible for the most people possible. So the biggest way that we're doing that is through grade level reading comprehensibility studies of our plain language content. So every time we write anything, we do an analysis for making sure that it's under 6th grade reading level. We always try to aim for 5th grade, just to make sure that the questions are understandable. And that's what we also always supplement. Anytime that we offer some legal concept on our platform, we supplement that with a plain language explanation of what that means.
Great. And so I think in part you also answered Nonopa's question, who basically asks, what about people who are not digitally savvy, right? And so
yeah. I mean, that another plan that we have too is just like, part of the reason why those populations are inaccessible is because a lot of the models for servicing those are like, you need to find us. And what we want to do is like really find those populations. So that's why our big focus right now in terms of early customer acquisition is through partnership channels, through community-based organizations that are already servicing those users. And hopefully that way we can find the populations that are traditionally the most inaccessible and then work our way up and to expanding into those for everyone who needs to use it.
Okay. So Luciana is asking a good question too. She's first of all, she says, hey, Amon, congrats. In Brazil, we have a similar and super powerful player called Use Brazil. I'm actually familiar with them. They became the platform for all lawyers and citizens to follow up on their cases and keep track of developments on the different processes. Although the Bar Association in Brazil basically is prohibiting to, I guess, commercialize the law with such kind of, do-it-yourself or kind of systems, right? Legal assistance systems. You can only use it for research purposes, but not to start like your own petition. And so I guess the question is, whether you're aware of similar regulations in the US. I guess, this goes to the broader question about unauthorized practice of law. There's, of course, those regulations, and there's been lots of litigation in the United States about that. And the line that's always drawn is, you can provide legal information in an automated, mechanized way, but you cannot provide legal advice. That's still sort of the domain for human lawyers, and that's sometimes very hard to draw the line. I remember our friend Eddie Hartman, one of the founders of LegalZoom, telling us that I think under the some interpretation of UPL rules, I forget which state it was, it's even if the machine sort of suggests that a person use Form A versus Form B to submit to the courts or the government, that is legal advice, and it should not be done in a machine automated way. Anyway, so totally. I'll let you respond to that, but that's just a little.
It's a big so this is absolutely. It's super complicated because I think in the U.S. in particular, we're getting a lot of contradictory results. There's a recent Upsolve case in New York where it's seeming like non-lawyers are going to be able to provide substantive legal advice to clients. And there was also, a year ago, a decision in Florida where an app that just did, as well you were describing, document automation, where all the inputs lead to the same exact amount of outputs, and that was considered to be legal advice. So we're trying to rely on the precedent established by other companies that have been in this space before. So we didn't start off by focusing on document automation because we did want to make sure, regulatorily speaking, that we were on the right line of things in terms of legal advice versus legal info. But as far as other organizations have offered in terms of self-help services and document automation, which I believe you're talking about, at least in Illinois, regulators don't seem to take that as unauthorized practice law, generally speaking. So we do feel that we could offer some sort of service like they're filling out the questionnaire and they say that in like George's case, they input that it's been less than 30 days since their order was issued. And then we could say like, hey, if you had a child support order that has been issued less than 30 days ago and you disagree with the order, you can file this motion to appeal that amount. And here's the link to a self-help service through which you can fill out this form. That we feel is totally possible, but sort of anything beyond that in which we try to sort of extrapolate a user's individual circumstances and give them a recommendation based on that isn't generalizable, that's where I've been told the line starts to get pretty gray. So at least in terms of simple document automation, we feel that we're fine with that. But anything beyond that, it's simply an in-person setting, we're not really interested in trying to fix those boundaries for sure.
Great. So you answered Shugam's question already about the business model, and we're getting to the end of our time. Jonathan's asking, how is what you do different from Illinois' Legal Aid Online?
Yeah, great question. So we've been in talks with them ever since the beginning. And so, I mean, the first differentiator that we would say, and that we both agree on from talking with each other, is that they aren't really focused on the diagnostic stage of a self-represented litigant's journey. Like they are focused on helping people who have already been to court or already know what their problem, and they have a suite of self-help tools and legal information articles and all that good stuff in terms of helping that user represent themselves in court on their own without a lawyer. And that's their domain. We're purely focused on that diagnostic stage, that litigant journey. So not only, informing them that their problem actually is legal in nature, but, if they went to court and something happened, what's the first action they need to take before, they miss a filing deadline or miss something else, and then their case is irreparably damaged. So that's where we really fit in, or we see ourselves really fit in differentiation to them. And so what we've been in talks with them recently is that, sort of like I was mentioning with document automation, what we could do is if a user comes to our site and they identify that they have a problem that Aleo offers a self-help form for, we can refer them to Aleo. So we get users and the user gets substantive help from them. Which is all to say that, we're not trying to compete with Illinois Legal Aid Online. We just want to help as many people as we can. And we're hopefully going to be working together to try to help as many people as possible.
Great, thank you. It's okay, so okay, so now there's the questions flying in. I will maybe take this is more of a comment or a question. Scott's asking if you compared with other self-help tools from other from other states like California, for instance. And then Sarah is asking, it sounds like your focus might be also on basic legal education to empower SRLs. Do you have any plans to expand that part of your product?
Totally, yeah. So on one hand, we are currently always trying to add legal information to the site. So we're regularly posting articles and definitions that explain legal concepts in plain language. But where we really feel like we need to go is sort of like on the ground community advocacy to facilitate that basic education. So we've already heard from the community-based organizations that we've reached out to for partnerships that they would be interested in some form of pop-up workshop where we, have little laptops and tablets and we host, know your rights workshops, or just provide basic legal information, or have a pro bono attorney sponsor and provide free legal help to focus on the community. There's definitely a big interest in that level of just general education. And we do think that's like super critical in terms of allowing communities to be more self-sufficient in triaging and solving their legal problems. So definitely we're looking forward to that, and hopefully we're looking to include some actual education information from people who have navigated themselves as separate litigants going forward.
Sounds great. Well, great. Let's close here. Thank you so much, Eamon. It was great to have you. It's a wonderful project too, and we're rooting for you. And please keep us posted. Thank you, all the participants, for your great questions. Thank you also to Julia for his great presentation today, and everyone who presented this quarter. I think there's a tremendous amount of excitement and opportunity in legal innovation, and we enjoy bringing this community together and facilitating conversations. I think it has been a really productive and interesting quarter. Looking back at all the sessions we had, if you missed some, you can find most of them in our CodeX YouTube channel. And might reach out over the summer. Maybe we have an ad hoc session sometime over the summer. We might schedule something, but otherwise we'll plan to pick it up again in the fall quarter with our sort of weekly cadence of these exciting group meetings and presentations. So thank you everything that you bring to this community, and be in touch and have a great summer. Thank you and bye-bye.